इतना नहीं है,
अच्छा।
हो जाएगा जल्दी।
सर, ब्लू कलम एक ही है क्या?
कब?
नीला चेम्बर में था भाई, आई तो एक ठो लगा पीछे से पीछे।
पेन।
ये ब्लू।
रेड रेड।
ब्लू यहाँ से ले भाई।
और अंदर में है नहीं तो चाहिए तो बोल ना, तो ले ले। ये तो रेड है। फिर ये भी रेड है।
Albert, moron ba okay pa tong tabay di na? Ito advocate ka mga computer di na.
Kudu.
Thank you.
Welcome. छः छः
एक नंबर
और एक नंबर तो देख लो।
नहीं सर।
और दिव्य नहीं, एक नंबर। तेरी का
ट्वेल्व
12
12
12। Dapat oke dah. Itu kau orang mungkin punya snap bro. Snap nama mana sih? Tuh atau sih. अभी जजमेंट का फाइल itulah court trigger blue pen asna necessary blue for judgment item number 5.
For reasons recorded in the judgment, this court is of considered opinion that the trial court, without there being any pleadings of the parties on record and evidence which was adduced in pursuant to such pleadings, has erred in arriving at the conclusion against each issues framed in the case. The procedure followed by the trial court in the said civil case was not accordance with law. The respondent Kiriti Viro could not have been joined as a plaintiff in this suit without his filing any pleadings, either plaint or written statement. And therefore, the impugned judgment and decree is hereby set aside. However, it is hereby made clear that the principle of actus curiae neminem gravebit, which means that act of court shall prejudice no one, becomes applicable to facts and circumstances of this case. And therefore parties shall be at liberty to seek appropriate remedy in appropriate proceeding before appropriate forum. And under the facts and circumstances of this case, the benefit of Article 14 of the Indian Limitation Act 1963 may be availed by the parties seeking to pursue appropriate relief. With these observations, this first appeal is hereby disposed of. The interlocutory application number, the 83 is hereby dismissed.
Motion, item number 6.
May it pleases your lordship. My lord, am I audible, my lord?
You are audible but not properly visible.
Yes, my lord.
Yes, yes.
My lord, I'm told that the weather in Kohima is pretty cloudy, and probably that has been a factor, which is why your lordship has not been able to see.
Oh, you are wrong. It is not cloudy today.
Okay. I stand corrected. My lord, this is an application under 482 CRPC for quashing of an FIR, which your lordship would find at page number 13. Now, my lord, this is a classic case where money lenders are using the court as a medium of recovering their the landed money, my lord. My lord, page number 13, my lord. Now, the FIR is lodged by the husband of a man who had admittedly taken loan from a person along with the petitioner. With reference to the subject cited above, I have the honor to report herewith for you for your necessary action, please, that sometime in November, December 2019, now, my lord, this FIR is of 2022, I approached Sri such and such to sanction a loan only to my wife, Rumi Shaha, and Sri Tinku Shutradhar. Tinku Shutradhar is before your lordship, my lord, for a business purpose to run a garment business at New Market, Dimapur. As such, basing on my request and trust towards me and agent Sri Sajib Yadav, who introduced us to such and also who stood as a witness, Sri such and such has arranged the said loan amount of 58 lakhs only in between a period of 3 years to the borrower, Srimati Rumi Shah. Rumi Shah is the wife of the informant, and Tinku Shutradhar, that is the petitioner before your lordship, which was given on installment basis through bank transaction, check, and some amount by cash. Thereafter, again, an amount of rupees 3 lakhs only was also sanctioned by cash in hand without proper documentation. However, despite of several reminders and lapse of over 3 years, the borrower failed to repay the entire loan amount and rather kept on renewing the loan agreement on 3 occasions. And on 14/2/2022, a loan agreement was executed between the lender and the borrowers, wherein the term of the loan was extended further for a period of 7 months, commencing from the date of the said loan agreement, which have been acknowledged by signing in the said loan agreement by the borrowers. However, it was learned that Sri Tinku Shutradhar, along with his family members, have fled from Burma Camp, Dimapur without repaying the loan amount, and their mobile phone has been switched off despite of several attempts. Sri Tinku Shutradhar could not be traced. That the above act of commission and omission of Sri Tinku Shutradhar clearly implies that he had the intention of not repaying the said loan, and thus my wife Rumi Shaha will be liable to repay the entire loan amount alone. Therefore, being a law-abiding citizen, and since my wife has a health complication and also I have been one of the witness, I hereby report this matter before your authority on my wife's behalf and act on her behalf till the matter is solved. And further, I request your esteemed authority to initiate necessary legal action in order to repay the entire loan amount to the lender after the said Tinku Shutradhar has been traced. Now, my lord, 2 or 3 things that transpires from this FIR is that they are alleging, the informant is alleging that his wife and the present petitioner has taken a loan of 58 lakhs. Now, my lord, interestingly, I don't find anything in the FIR regarding what was the mode of payment. They say bank transaction, no detail, no date, no check number, nothing, absolutely vague. Now, my lord, they say that this loan was taken from the lender in the month of November, December 2019. And then they say that this loan was given over a period of 3 years in installment. Nothing specifics comes out. Now, my lord, thereafter they say that even after lapse of 3 years, we have not paid the loan. Now, my lord, I take a pause here. Now, suppose, my lord, a loan of 58 lakh the initial payment, let me presume that the initial payment was made in the month of November, December 2019. Then, my lord, 3 years will elapse in 2022 November, December. This FIR is lodged on July 2022. Now, then, my lord, how can he say that in the month of July, 3 years have elapsed? Because this loan was not given in one go according to their FIR itself. Now, my lord, this FIR was interestingly registered under section 406 and 420. My lord, as your lordship is already aware, 402 cannot go hand in hand with 420 because the ingredient of one section negates the other. Your lordship is aware, my lord, under 406, my lord, the initial entrustment has to be genuine. It has to be without any deception or without the initial entrustment was correct. However, subsequently, there has been a misappropriation. And for 420 to come in, the initial entrustment has to be based on some deception or dishonest intention. So, my lord, 406 and 420, my lord, cannot go hand in hand. And, my lord, this is a common phenomenon, my lord, we have seen where, my lord, in such type of cases, both these sections are imputed, my lord, both in Assam as well in Nagaland and in many parts of this country, my lord. Now, my lord, I can understand the police making such mistake, my lord. Now, interestingly, in this case, my lord, the judicial magistrate has framed charges under both 406 and 420. I'll take your lordship to that part. But before that, my lord, it would not be inappropriate to take your lordship to the so-called agreement which was executed between the parties, which your lordship would find at page number 14.
Now,
My lord, this
you are aggrieved by framing of charges? Or
I am aggrieved with the FIR, the frame charge sheet and framing of charges, my lord. Under this, I have challenged all these three, my lord, the FIR as well as the framing of charges.
If you are aggrieved by FIR, you are too late because already
My lord,
charge sheet has.
my lord, my lord, I am also aggrieved by the framing of charges as well. I have assailed all these three, my lord. I have not only assailed the FIR, my lord, there are judgments to suggest, my lord, that when we challenge the framing of charge order, my lord, we are at liberty to even challenge the FIR and the charge sheets, my lord. At the appropriate time, my lord, I'll rely on all this. Just before that, to prima facie show that this case does not call for a trial, my lord. My lord will kindly come to page number 14. Page number 14 for a while. That's the agreement. Now this, my lord, is there at page 14?
Yes.
Now, my lord, will see the date of this agreement.
You are not visible whether his video is this is becoming an audio conferencing.
Oh, I'm extremely sorry, my lord.
Yes.
My lord, am I?
Now it is okay.
Now it is okay. Next time,
yes.
Yes, my lord will see page number 14. Now, my lord, according to the FIR, the loan was taken on November, December 2019. That's what is there in the FIR. Now, let us see, my lord, what this agreement says. This agreement is made and executed at Dimapur on the 14th day of February 2022. Sri such and such, son of such and such, resident of such and such, Rumi Shah. Rumi Shah is the wife of the informant. And that's Tinku Sutradhar, that's the petitioner before your lordship. I skip the rest, address and father's name, all this. Whereas the second party, borrowers, is in need of financial assistance for her, his personal purpose for which she approached the first party lender to finance her, him, financial help without interest with a sum of rupees 55 lakhs. And whereas the second party borrower surrender his. Now, my lord, here the lender says that it is free of interest. My lord will see the next para, my lord. These things raises serious eyebrows, my lord. And whereas the second party borrower surrenders his or her trade license, license number such and such, and a plot of land measuring such and such, covered by such and such, at such and such, lender as a security against the loan. Now this agreement witness as follows, that the first party lender has accommodated the second party borrower with a sum of rupees 55 lakhs. My lord, again, no specific, nothing, no bank detail, nothing. My lord, I'll come to the actual fact later. Only which the second party borrower admits, acknowledged by signing this agreement. that the parties agreed that the term of loan will be for a period of 7 months, commencing from the date of execution of this agreement, and the second party will pay the entire loan amount at the expiry of the given time period. That the second party will pay the entire loan amount of such and such only on or before 31st August 2022. Next, that the second party being the sole and absolute owner of his trade license number, patta number, there's the land document. I come to the operative part, shall be at liberty to claim, that's the first party will be at liberty to claim the said license and further may proceed for change of ownership with respect to the said license in the name of the first party lender. That the second party borrower will not make any excuses relating to any situation and problems for repayment of the loan amount, and the second party borrower will repay the entire amount as per the terms of this agreement. That it is further hereby agreed that the first party lender shall have sole and exclusive right to take further steps, including publication in the daily local papers against the second party borrower for recovery of the said amount if each of the parties fail to abide by the terms and conditions of this agreement. Now, my lord, this agreement is between the lender and the borrower. One of the borrower, admittedly, my lord, is the wife of the informant. Now, my lord, in the FIR, he says that this loan period was given in 2019, November and December. There is no reference in the loan agreement. This loan agreement, in fact, was executed under pressure, my lord. There was nothing in this loan agreement. They could not come up with a single specific detail. My lord, an amount of rupees 55 lakhs, my lord, there has to be some money received, some bank transaction, some check number, something just to, my lord, prima facie show that the transaction is genuine. In fact, what had happened, my lord, a small sum of, during the COVID time, the petitioner and the present, the wife of the informant, they had taken a small loan amount of rupees 15 lakhs or 20 lakhs, my lord, which was repaid. It was given on an exorbitant interest, my lord. Now, this agreement is executed calculating the entire interest, my lord. Now, my lord, I ask to myself, can unscrupulous moneylenders use criminal code for recovering their use criminal code as their recovery agent, my lord? My lord, where is 420 and where is 402, my lord? 406. 420 is if by deception I induce somebody.
No, Mr. Bishas.
My lord.
There may be, in this case, it may happen that it may be purely a civil dispute.
Yes,
but
my lord.
Here, investigation has completed, and in investigation, it was found that ingredients of 420 and 406 are there.
My lord.
So,
my lord, the perfunctory nature of the investigation, your lordship will be satisfied once your lordship comes at page number 22. My lord, in my respectful submission, my lord, under 482, my lord, subject to correction, your lordship is empowered not only to quash an FIR or a charge sheet, but any order which prima facie does not satisfy or which prima facie does not call for a trial, my lord. My lord, page 22, your lordship will see the list of enclosure. On the basis of this enclosure, how can the investigating agency come to a conclusion that such and such money was given to such and such person, my lord? There is nothing, not even a single money receipt of 1 rupee.
yes, Miss Mary. We'll issue notice.
My lord, on 20th, I have the next date. My lord, I am from Nagaon, my lord. Will kindly, my lord, I oblige to what your lordship, what had fallen from your lordship will issue notice. Only till the returnable date, my lord, let me stay in my hometown, my lord, because, my lord, I had also paid, because there is another important thing, my lord.
You are appearing before you
yes,
have,
I am.
you are on bail. You took bail, you appeared before the trial court, charges are framed, you contested framing of charges.
my lord, I sought for it on the, my lord, I tried to, my lord, because after I have went to Dimapur, my lord, I could not collect the certified copy. Only very recently, my lord, I have collected the certified copies, my lord. My lord, the thing is that, my lord, once the petitioner has realized that this case can be moved under 482, he has approached us in Gauhati, my lord, and that is how we have, my lord, these are small time businessmen, my lord, they earn their livelihood, maintain their children by running some small garment shops, my lord, to
We-
expect,
We'll
to
look,
my lord.
but at this stage, no stay.
My lord will kindly, my lord, otherwise I will be highly prejudiced, my lord, only till returnable date, my lord. If I cannot convince your lordship, my lord,
How
your lord,
will you be prejudiced? When
my
you
lord will,
are already appearing before the trial court.
my lord, my lord will kindly consider, my lord, only till returnable date, my lord. My lord, on the returnable date, if I fail to satisfy your lordships that this case does not call for a trial, my lord, your lordship is at liberty to pass any order, my lord, only till the returnable date. And my lord will kindly see what is, how my wife is, how my wife is, my lord, trying to maintain his family. My lord will see at page number 34, my lord.
Just for staying the proceeding, there has to be strong ground.
My lord, the ground is the FIR prima facie, my lord. The
The-
investigate,
This case has moved beyond FIR.
my lord. I take your lordship, my lord. I take your lordship to the framing of charges order, my lord. Will kindly come to the charge framing order in that event, my lord, which is at page number 30. My lord, will this order stand the scrutiny of law, my lord? I leave it to your lordship, my lord. Accused person such and such present along with such and such learned APP such and such present for the state heard both the parties on the point of charge. As such, on consideration of the submission of the charge sheet file, it is the opinion of this court that there are sufficient material to proceed against the accused 420406. There is no whisper, not even half a line. What ingredient of 420 and 406, my lord? My lord, if I understand correctly the principle of framing of charges under 223, my lord, it has to be strong suspicion.
No, there are sufficient materials.
My lord, this is just an English phrase which has been written, my lord, without there being any material, not even half a line. Not even half a line, my lord, will kindly appreciate, my lord. Only till the returnable day, my lord, no, because this is they are challenging, my lord, because absolutely this man is harassed, my lord. He has not taken this money, my lord.
No, we'll consider your prayer, but this is not a case. I'm unable to convince myself that this is a case where stay should be granted. Yes,
My
Ms.
lord,
So your
my lord,
there is a prima facie case established under 406 against the accused, your
Okay,
lordship.
we are issuing notice.
Yes, your lordship.
Your prayer for stay would be considered only after receipt of the scan
my
copy.
lord, may I, my lord, let my counsel take steps, my lord. My personal appearance on 20th may kindly be dispensed, but only to that
No,
effect. So,
Well,
that will amount to your lordship.
my lord,
That
on,
prayer-
of
That you are at liberty to move the trial court with that prayer under 205.
my lord, that liberty at least may be given. And my lord, if I may pray, my lord, if your lordship fixes any date subject to your lordship's convenience, and if your lordship observes that an endeavor is to be made to dispose of the petition on the next date fixed, my lord, I'll be obliged, my lord, only, my lord, so that, my lord, these parallel proceedings both before the trial court and this 482 does not get infructuous, my lord. The prayer in 482 does not get infructuous, my lord. Because the informant is also not traceable, my lord. It will take time for issuing notice and to serve the informant. I will take steps during the course of the day, my lord. I will take steps during the course of the day. Even if I fail in taking steps, if I delay it even for one day, my lord, your lordship is at liberty to vacate my interim, my lord. I am just urging before your lordship only because, my lord, so that this 482 petition does not become infructuous.
Abhishek's question of vacating will arise only if I grant it. I'm
No, my lord. That is precisely my prayer, my lord. That is precisely my prayer. What I'm submitting is that, my lord, in case, my lord, I will take steps during the course of the day, because, my lord, in this case, I know, my lord, because this present informant is also untraceable. This FIR was filed, the informant was pressurized to file this FIR against me. The informant was literally pressurized. The informant is also untraceable. I am running my family. I have a minor child, my lord. I am doing a small business in the district of Nagaon, my lord. My lord will
Heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Ms. S. Mere, learned public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Tinku Sutrodhar, praying for quashing of FIR, which was filed on 24/7, which was lodged on 24/7/2022 by one Shri Bindyut Saha before Dimapur East Police Station, and on the basis of which Dimapur East Police Station case number 158/2022 was registered. The petitioner has also prayed for quashing the charge sheet as well as quashing the charge sheet number 26/2022 dated 22/12/2022, as well as the order dated 14/8/2023, by which charges under section 406/420 of the Indian Penal Code were framed against the petitioner. In what is the GR case?
488/2022.
In GR case number 488/2022, pending before the Court of Learned Judicial Magistrate First Class, Dimapur, Nagaland. Issue notice to the respondents and call for the scanned copy of the case record of GR case number 488/2022, as well as scanned copy of the case diary of Dimapur East PS case number 158/2022. As Ms. S. Mere, learned public prosecutor, has appeared for the respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 2 days from the date of this order. The notice is returnable on give 2 weeks time. Albert, give a date to be. 27th March 2024. The prayer for interim relief made by the learned counsel for the petitioner would be considered only after receipt of the scanned copy of the case record. Further, regarding the prayer for dispensing with the personal appearance of the petitioner before learned trial court, the petitioner may approach learned trial court with this said prayer, and if such prayer is made, the learned trial court shall consider the same as well. Let this case be listed on 27th of March 2024.
For admission, item number 1.
May I please, Lordship? Lordship, I have received the affidavit in the possession file in the office for me, no one until today. has subsequently done 1 week's time to file my affidavit in reply, my lord.
This is civil revision petition.
Yes, your lordship.
Whether the case has been, LCR has been called for.
No, your lordship.
Heard Miss
Nagarishwar.
Nagali Shoy, learned counsel for the petitioner. Also heard Miss, what's her,
Hijabitsu.
Eza,
Yes, hijab.
Miss Eza, learned counsel for the respondent. Learned counsel for the, what will you file?
Lordship, I just received the affidavit in opposition, so I have to go through. what-
No, this is a civil revision. Here
Yes,
you
Lord.
need not to file.
No, Lordship, but I just received a reply message. If I will be allowed to go for the reply.
Learned counsel for the petitioner has submitted that the petitioner has received the objection in the form of affidavit from the respondent only recently, and she needs some time to go through the same. And on that ground, prays for some time, stop. Prayer is allowed. It also appears from record that in this case, in this civil revision, the order passed by Lanet Civil Judge Senior Division Dimapur on 4/8/2023 in IA Civil number 86/2022 has been impugned. However, the record of the said IA Civil 86/2022 has not yet been called for. It appears that perusal of the said record would be necessary for consideration of the instant civil revision petition. Hence, call for the record of IA Civil number 86/2022. List this case again after 2 weeks.
Much obliged. Much obliged.
For admission, item number 3.
You have to inform the. Okay. Yes,
May I please, Lordship.
yes.
I pray that I may be given some time to file my necessary affidavit, my lord. I am appearing for the respondents number 2, 3, and 4.
In item number
2.
2, 3, and 4.
Yes, my lord.
Okay.
I am for 1.
You are Miss Anungla Helkiar. Heard Miss Anungla Helkiar, learned counsel for the petitioner. Also heard Mr. N. Long Kumar, learned counsel for respondent number 2, 3, and 4, who prays for some time for filing affidavit in opposition. Also heard Mr. N. Angami, learned senior government counsel appearing for respondent number 1. The prayer made by learned Mr. N. Long Kumar is allowed. Let this matter be listed after
3 weeks.
3 weeks.
For admission, item number 3.
Because Your Honor, I have a prayer with your lordship, so that directly became the respondent of your lordship. Here, lordship, the issue is this, lordship, the petitioners want to retreat.
Petitioner?
1 to 23.
Okay.
Yes, 1 to 23, they are all.
1 to 23.
Yes, they're literally petitioners.
Okay.
And then petitioner number 2 and 23, we are class conductors, and then the rest are the drivers, lordship. And then this honorable court lordship is directed to grant minimum scale of pay as well as to be errors on the date of filing of the petition.
Okay.
And then in the regular deposition of in the present implementation, your lordship. Of respondent number 2, your lordship. It's paragraph 3. May I take the lordship?
Of respondent number 2.
Yes, lordship. In paragraph 3, that is page 2 of the.
Yes.
May I read the lordship?
Yes.
That in compliance of this honorable High Court order dated 27/2023, passed in declaration number 130 of 2022, the answering deponent respectfully states that the answering deponent is taking all initiatives and following all protocol procedures so as to comply with the order in direction of this honorable High Court. The answering deponent respectfully states that in following the protocol procedures, it usually takes time as the procedure for grant of minimum scale of fee to all the bunch of the petitioners involve huge financial implications. Be that as it may, the answering deponent respectfully states that the answering deponent is diligently taking all initiatives to comply with the order and direction dated 27/2023 passed by this honorable High Court lordship. They clearly see that they are taking all the initiatives for complying of the honorable court order, but in your lordship, they have not enclosed any documents, your lordship. So in the only documents which they're just saying that they are taking the initiative, so there's one particular direction to be given to the respondent number 2, which the competent authority that after the in compliance of the honorable court order, whether any office order has been issued or lordship for granting of those must be obeyed, lordship. Because the statement in the affidavit.
But statement made on affidavit also has value. But you have to comply with that statement.
Yes, your lordship, I represent the respondent number 2, the additional chief secretary and financial commissioner. Lordship, this grant of minimum scale of pay order was passed on 27/2023, allowing us state respondents 3 months time by this honorable High Court. But there were some technical problem, your lordship. After the order has been passed, in some other case, state has filed a special leave petition before the honorable apex court, challenging the order, not this order, another order for grant of scale up pay. So while waiting for that, this judgment to be pronounced by the honorable High Court, this 3 months time was lapsed. State has filed. Your lordship may kindly appreciate for grant of scale up minimum scale up pay before the honorable apex court by way of SLB number 35341.
No, but that
And-
is with regard to other case, not this case.
That is all filed during 2023, your lordship. So the authority of the state was waiting for that, the outcome for grant of minimum skill of pay. And in the process, 3 months' time was left. But now, as I have stated in my affidavit, we are taking all the initiatives.
No, what initiative you have taken?
Lordship, we have formed
You have
a
not-
committee.
Annexed any documents to show that some initiative on your part is there?
Yes. We have initiated a committee, constituted a committee, your lordship, 16 February 2024. And
This committee is will,
Yes, yes.
what it will consider?
yes, because it is. Lordship may kindly appreciate, we have a lot of contingency and fixed pay employees in the state. So in order to consider all these things, we have considered a committee and the initiative is going on. And so far as the petitioners has been concerned, your
No,
lordship.
no, this is very general statement. This you will take a policy decision. But as regards this case, there is a specific direction. You have not filed any appeal against this order.
That is why, your lordship.
Then you have the only option is to comply.
When the order was passed by this Honorable High Court, we have already met in SLB before the Honorable Apex Court.
Not
So
against this.
while waiting for the judgment in order to be passed by a decision to be made by the Honorable Apex Court,
In a similar
the 30 days time was left, your lordship.
No, but it is now much more beyond, much beyond that 90 days.
Your lordship, and so far as the petitioners has been concerned, in this contempt proceeding has been concerned, we are taking the initiative. But total procedures are there. It has to come from the department. They are in the Department of Business and Accounts. It has to come from the department to the government and from government to the PNR to the finance and then back and then to
No,
the state cabinet.
No,
So
you have to specify within what time you will comply with the court's order.
lordship.
Otherwise you can go on,
no,
on and on.
it is not like that. We are taking the
Limited time.
initiatives. We are taking the initiatives and the file is with the Honorable Sims office. Now, your lordship, kindly grant me 6 months time.
No, 6-month time was not granted by the
If
original.
my friend agrees. Because total procedures are there.
No, are you conceding?
No, your lordship, as your lordship is pointed out, your lordship, lead, third respondents, counsel for the third respondents may be give direction to file an additional affidavit by posting the documents what initiatives they've taken, your lordship. So on the basis of.
No, today he has filed a notification that a committee
Your
has
lordship,
been,
with regard to this notification, your lordship, it's just
but this is a general
Yes,
notification.
lord.
As regards specific, any step specific to this case.
That is what, in so far as the petitioners has been concerned.
And then in the affidavit also, they clearly stated that you are complying this honorable court, that means they will be, they are taking the initiative to grant the minimum scale of the lordship.
No, you stated that you are taking all initiatives without specifying what initiatives have you taken.
Your
Other-
lordship, allow
other-
me 6 months time. By that time,
6 months is.
we will definitely grant. If my friend agrees.
Your lordship, 6 months time, your lordship, that's not acceptable, your lordship, and then moreover, the honorable, apex court, your lordship, that particular matter, your lordship, for granting scale of pay, your lordship, it depends on the certain facts and circumstances of the case. And then we are in the present case, your lordship, the department in the RTI reply, you have clearly stated, your lordship, they are all performing similar duties. So on the basis of that, this honorable court is clearly given direction for granting those.
No, your lordship, we are not waiting for this order from the Honorable Apex Court. My explanation was why it was been delayed, why the initiatives for regular for kind of skill up pay to the petitioners
No,
was
now
delayed.
you have to either,
On that aspect only I am saying.
no, Mr. M. Chen.
We thought some judgment will come from the Honorable Apex Court. That is why 30 days was left, 90 days was left.
My understanding is when this court has passed an order
Correct,
directing you to do something within a
Correct.
stipulated period of time,
correct.
you have two options. either to go on appeal against the said order if you
Yes.
are aggrieved, or to comply.
Correct.
You have not
correct,
gone on appeal, neither
Correct.
you have complied, but you have given an explanation
Correct.
that why the delay has been caused. But now, not only 3 months, it is more than almost an year has been passed.
That is why I'm saying, Your Lordship.
So you have to now either comply or to face contempt.
No, since SLP was filed, we thought some judgment will come. That is
No,
in the
that I have
process.
understood.
In the process,
That you need not to repeat.
3 months time was left.
Now you have
That is the only
to give an undertaking that in how much time you are complying with the orders.
Lordship, if my friend agrees 6 months, but
He's not
if he
agree-
says no, then at least 4 months, Your Lordship, because total procedures are there.
Lordship, after it's supposed to spend 8 months, Your Lordship. And then the only issue is whether this honorable court order has been complied upon. Your Lordship.
Yes.
For granting, this is not for extension of time, Your Lordship. It's
No,
not termination.
Your Lordship, I admit, I said, I'm the additional Chief Secretary and Financial Commissioner. We are taking the steps, Your Lordship. We are taking the initiative.
No, you have to take initiative within the time allowed.
I have
Or
sent the
if
file to the
if-
Chief Minister's office.
No. If you have any grievance against the period granted, you could have appealed, you could have prayed for extension of time before
That is what I'm saying.
before the original court, not the contempt court,
Correct, you're right.
the court which granted the relief to the petitioner.
Correct. Your Lordship.
Before that court or before appellate court, you could have prayed for extension of time. But this is contempt court, which will only see that you either comply or face contempt.
Correct.
That
correct,
is the only
correct.
limited.
Lordship.
So we may give some time if you assure that you will comply
Lordship,
within.
allow me 4 months' time and close this contempt. If
Four-
my friend agrees.
Your Lordship, if the state's respondents are, if they are ready to comply this honorable court, Your Lordship, then 30 days, Your Lordship, 1 month, Your Lordship. Sufficient time is been given, Your Lordship.
Lordship,
Otherwise,
1 month's time will be too short.
otherwise you have to face, otherwise the finance secretary shall have to come personally
Correct. Your Lordship. Your Lordship.
and to explain why he is unable to comply with the court's order. Heard Mr. Supamvati Baling, learned counsel for the contempt petitioner. Also heard Mr. Moa M. Chen, learned senior government
Yes, Lordship.
Counsel.
Correspondent number 2.
for respondent number 2, as well as Mr. V. Zumomi,
For respondent number 1.
learned counsel for respondent number 1,
And respondent number 3, Lordship.
and Mr.
S. Imli for respondent number 3.
Mr. What's your name?
S. Imli.
S. Imni for respondent number 3. Learned counsel for the petitioner has submitted that though the respondent number 2 in his affidavit in his affidavit which was filed on 16 February 2024 has stated that the respondent number 2 has been taking necessary steps to comply with the order dated 27/2023 passed in WPC number 130/2022. However, as following all the codal formalities requires time, the learned counsel for the learned senior counsel, senior government advocate, Mr. Im Chen, prays for some more time to for complying with the said order. It is also submitted by learned counsel that in a similar matter, the state has preferred a special leave petition before the Supreme Court of India, and the state was expecting some orders in that case, which has caused delay in compliance with the order against which this contempt petition has been filed. Yes, Mr. Wali. What is to be done?
Also, 30 days correction, to strictly comply with the Supreme Court order.
Within 30 days.
Also 4 months time. 4 months.
No, no.
We are initiating.
No. The
If our friend agrees.
considering the submissions made by learned counsel for the learned senior government advocate representing the respondent number 2, 45 days are granted to, 45 days more are granted to the petition respondent number 2 to comply with the order dated 27/2023.
Lordship, at least 60 days. 60 days.
No.
60 days, I pray. So because the procedures
No, you try to comply within, because already almost an year is lapsing. So unless you fear contempt, you will not comply, at least accordingly after the said period.
obliged.
For admission item number 4.
Yes, my lord. This is the application frame for extension of time by 6 further months, lordship. By passing order dated 23/3/2023, this honorable court has allowed 8 months time to grant to allow the respondent authority for granting of time-bound of scale of pay. Now, the members of the petitioners, the writ petition, there runs into several hundreds of numbers, covering more than 30 divisions. And involving huge financial implications, lordship. So, in pursuance to the honorable order 23/3/2023, the department has convened a meeting on 14/4/23. Then thereafter, again on 7/6/2023, direction was issued to the engineer. The chief engineers issued direction to the chief engineers of various wing to prepare aerial bill and submit the same within 2 months. Now the process is going on, but still things are not working very fast. That is admitted.
You have filed the affidavit which
Yes.
you were asked to file.
Yes, then thereafter, it was moved, this application was moved from 15 to 24, by which the honorable court has directed the petition applicant to file
Additional,
affidavit stating the step taken after 7/6/23 and of the latest status lordship. Now the latest.
you have filed the affidavit?
Yes, lordship.
So much, okay.
Additional affidavit.
Now what steps you have taken?
Lordship, now the departments, the divisions, they are still, many of the divisions could not submit the compile and submit the aerial bills of the members of the petitioners association. So again, a fresh direction was issued by the engineer in chief to the chief engineers on 22/20/2024, and on the next day, the concerned chief engineers have also again issued a stern direction to the divisions executive engineers to submit it within 1 month. That is the latest status, Lordship. So since the number involved a huge number, the members involved a huge number, Lordship, we.
How many
pray for-
petitioner is an association
Yes, yes.
or individual members?
We- Association.
How many members are there?
According to my learned phrase, about 2,000 Lordship. But
Okay.
now here the beneficiaries will be over, around, I think not less than 1,000 maybe. I'm not too sure, but several hundreds for sure. So in such a.
What was the direction
Lordship,
to grant
To
minimum
grant time bounds for scale of as per
Yes.
the ROP rules 1993.
to whom?
To
To
the
a,
members of the petitioners, that is the.
all
workshops
members
members.
or to the eligible?
Eligible members.
So some exercise has to be
Yes,
carried
yes.
out to find out who are eligible.
yes.
So that is why this contempt was filed?
Now, 8 months time was given, Lordship. And
For,
as usual,
for completing that exercise.
yes, and as usual,
The-
department could not complete the
complete
process
within-
in by 22 November last year, so contempt was filed.
So you have prayed for
Another 6 months, Lordship.
another 6 months
Lordship.
by in this interlocutory application.
Yes, yes, Lord.
Your Lordship, after the disposal of the earlier proceedings, this honorable court is graciously given 8 months on the basis of the prayer, on the basis of the David.
No, what was the original time given in the
8 months, Your Lordship.
in the writ petition?
Yes, Lordship. Then
In
the
the-
8th month
in the-
start on November 2023,
Okay,
and then now it's
when that 8 month lapsed,
22 November 23, Lordship.
okay, 22 November 2023. So even after that, November,
and then now
December,
after 3 months, now they are.
4 months have again lapsed.
Yes, Lordship.
So already a year is been passed, Your Lordship. And then, since in your additional evidence, they stated that the divisions have not submitted the details, Your Lordship. So Your Lordship, 6 months, I think that's too much for the listeners, Your Lordship, since they all are workers, employees, separate for employees, Your Lordship. So.
But why this, the details are not furnished? Who is not furnishing the detail?
These are the informations I've been supplied with, Lordship. So I think now department is giving a serious consideration now, Lordship. So my prayer is that if some time may be given, 6 months time may be given, Lordship, this is, at least for this time, Lordship.
Your Lordship, it can be disposed of whether Your Lordship, strict direction to comply. Your Lordship, within period of 2 months, Your Lordship.
No, it has to be realistic actually.
Yes.
It is, there are more than 1,000, there would be more than 1,000 beneficiaries.
That is involving huge.
But still, it is going to be 1 year.
Exactly, Lordship.
Your Lordship, I leave to the court, cabinet and your.
Heard Mr. KV Angami, Learned Government Council for the applicants. Also heard Mr. Supangwati Walling, Learned Council for the opposite parties. In pursuant to the directions given by this court on 15/2/2024, the petitioner has filed an additional affidavit detailing therein the steps taken by the petitioner for complying with the order dated 23/3/2023 passed in WPC number 268 within bracket K of 2022. Learned Government, Mr. KV Angami, Learned Government Council has submitted that as the number of beneficiaries under the order passed by this court on 23/3/2023 would be more than 1,000.
Several hundreds, Lordship.
Several hundred, would be several hundreds, hence the compliance of the said order is taking some time. It is also submitted that the respondent number 8, that is Chief Engineer PWD within bracket housing, and additional Chief Engineer PWD within bracket R and B, have directed the divisions under their respective jurisdiction to work out the details and furnish the same. What details?
To compile and Lordship, compile and prepare the areas of the aerial bills, Lordship.
Which para you have?
Uh,
Details which are required for grant of time-bound scale of pay to the eligible members of the Petitioners Association in WPC number 268/2022. And it is submitted that as the numbers of beneficiaries are more, some more time, 6-month times may be granted to the petitioners for complying with the order of this court. On the other hand, learned counsel for the opposite party has submitted that initially 8 months were granted to the petitioners for complying with the order. However, it appears that they have failed to comply with the order within said period of time. Learned counsel for the opposite party has also submitted that considering the large number of beneficiaries, a reasonable time may perhaps be granted to the petitioner for complying with the 4 months. 4 months.
I don't know whether that information
May not be sufficient.
Mm.
Okay. Considering the submissions made by learned counsel for the parties, as well as considering the averments made in the additional affidavit by the petitioner, further 6-month time is hereby granted to the petitioners to comply with the directions of this court in directions of this code, which was given, which was issued on 23/3/2023 in WPC number 268/2022. With this observation, this interlocutory application is hereby disposed of.
얘도 디스포스지. 우리 들러 껴도 먹어야 돼. 잘로.
Oigo.